deadly weapon. And the state would, again, reiterate the fact that we are asking the court to impose 2 separate prison sentences for each of the 3-year firearm specifications. Even though the underlying offenses merge, the case law does require us to do that. Thank you.
All right. Mr. Bradley?
Judge, we are ready to proceed with sentencing as well. We have reviewed the pre-sentence report. The information in there is substantially accurate and complete. We too have filed a sentencing memorandum, and I'm not sure exactly how you want to proceed here at this point in time.
I want to start with you and Mr. Post, if you'd like to speak, or anybody else. Okay.
Well, taking the last point first, insofar as we do intend to pursue an appeal in this matter, and we have instructed our client not to make any further statements at this time. All of that said, Judge, you sat through this entire trial. You sat through Mr. Post's testimony, and so I think you've heard his view on this particular case.
Right.
I also don't want to be redundant in terms of the information in the pre-sentence report. It is quite thorough, and you can see from the report he's 63 years old, does have significant health issues, no prior felony history, some limited misdemeanor history, albeit I think most of it, 25 or 30 years ago. A long history of meaningful employment. He's a military veteran, husband, father, homeowner. In the big scheme of things, a solid citizen here, and we continue to maintain that we believe he acted in self-defense here. He was, I understand that the jury rejected that defense, but nevertheless, that we continue to maintain that was the motivation here in engaging in the conduct that he did. Regardless, considering the totality of his 63 years on this earth, this would be considered aberrant. There's no indication that he's otherwise engaged in this sort of violent behavior in the past. And taking into consideration that his age and health and lack of criminal history, and what would a minimum sentence to the court here would be 8 years in prison, and we think that would be an appropriate sentence, and that's what we're asking you to impose here today.
A courtroom fell completely silent as the judge exposed every decision that led to a near-fatal shooting. The defense tried painting 63-year-old Mr. Post as a respected veteran husband and hard-working citizen who acted in self-defense after a road rage confrontation spiraled out of control. His lawyer begged the court for mercy, arguing this was a single tragic mistake from a man with no serious criminal history. But prosecutors weren't buying it for 1 second. They said this wasn't fear, this was pursuit. According to the state, Post followed Devin Quigley for miles, ignored multiple chances to leave, armed himself with a loaded gun, and deliberately chose confrontation over escape. Prosecutors reminded the court that Devin suffered life-threatening injuries, multiple surgeries, permanent nerve damage, and psychological trauma that will haunt him forever. Then the judge dropped the hammer. He said the entire shooting was completely avoidable from beginning to end. The courtroom listened as the judge described how Post pulled the firearm from his center console long before the shooting happened, proving he intended to use it. And when the sentence finally came down, 2 consecutive 3-year firearm specifications plus 4 to 6 years for felonious assault, the reality hit hard. A single moment of rage destroyed multiple lives forever.
Thank you. And Mr. Post, in line with what Mr. Bradley said, you're not going to speak at this hearing, is that correct?
Yes, sir.
All right. You have the opportunity if you want,
Yes.
right? Okay.
Thank you.
All right. And I won't consider that for any purpose. Ms. Tuttle?
Thank you, Your Honor. The state is requesting that the court impose those 2 3-year prison terms consecutive to one another, consecutive to a prison term of 4 to 6 years for the underlying felonious assault charge. When we look at seriousness and recidivism factors here, we have to look at the fact that this is more serious. The victim suffered serious physical and psychological harm as a result of the defendant's conduct here. There aren't any factors that make this less serious. If the court were to consider the victim's conduct here in starting some sort of altercation, that would undercut the jury's verdict. The jury did find that the defendant, beyond a reasonable doubt, was not acting in self-defense. Therefore, the court should not consider any factor of the victim provoking the defendant or starting something here, because that would be against the jury's verdict. Turning to recidivism factors, It's important to note that the defendant shows no remorse at all whatsoever. Defense counsel stated that the defendant feels that he genuinely regrets that the incident took place, but all that the defendant regrets is the consequences that are happening to him. He feels no regret, remorse, or sadness for what happened to Devin. He feels no remorse for pulling the trigger. He feels as though he was entitled to do that, and that's very clear from his jail calls. It's very clear from his statements in the pre-sentence report. He's been cold and detached anytime that he's talked about what happened to the victim here. He said that the victim brought this upon himself, and he's made statements demeaning the victim and his family. The ORAS, what was striking to the state here, is that the ORAS shows that he is a high risk in criminal attitudes and behavior. That goes hand in hand with his lack of remorse. Nothing about his conduct or his words leads the state to believe that he would make a different choice if he was in this situation again. Throughout their filings, defense counsel has stated that all the defendant wanted to do was not be badly beaten or not get into a fight. But the defendant made a series of choices that day. And those choices put him into this situation. And those choices demonstrated exactly what the defendant wanted that day. This didn't happen to him. It wasn't an accident. He wasn't in the wrong place at the wrong time. He was exactly where he chose to be, exactly when he chose to be there. It was the defendant who followed the victim for miles. It was the defendant who chose to tuck a loaded gun into his waistband. It was the defendant who chose not to call police. It was the defendant who chose not to change his route home. It was the defendant who chose to get out of his car at the Cleveland Clinic. It was the defendant who chose to punch Devin Quiggle in the face. And it was the defendant who chose to shoot Devin Quiggle multiple times. Devin didn't want to be shot that day. Devin didn't want to be followed home by the defendant. Devin didn't want to be transported by ambulance and life flight. Devin didn't want to have 2 life-saving surgeries. Devin didn't want to spend 11 days in the hospital. Devin didn't want to suffer permanent nerve damage. Devin didn't want to have part of his colon removed. Devin didn't want to deal with the psychological damage that is a result of the defendant's conduct. Devin spent more time in the hospital than the defendant spent in jail in 2025. And he has to live for the rest of his life with these injuries and with the harm that the defendant caused. That's why we're asking the court to impose.
The prosecutor's words cut through the courtroom like a knife. He feels no remorse. That was an explosive claim made moments before a judge sentenced a 63-year-old military veteran for a brutal roadside shooting that nearly killed another man. Defense attorneys argued their client was terrified and believed he was protecting himself during a confrontation that escalated out of control. But prosecutors revealed a much darker version of events. They told the court the defendant wasn't trapped or cornered. He hunted the victim down. They said he followed Devin Quigley across town, carried a loaded firearm, ignored every opportunity to leave, and intentionally escalated the situation step by step. The state even revealed disturbing jail calls and statements where the defendant allegedly blamed the victim for being shot multiple times. Prosecutors argued the victim never asked for any of this. Not the ambulance ride, not the emergency surgeries, not the permanent injuries, and not the emotional scars. Then came the judge's devastating conclusion. He said the defendant chose confrontation over peace from the very beginning and believed the gun was removed from the car long before the shooting because he fully intended to use it. Seconds later, the judge sentenced him to years behind bars as the courtroom sat frozen in silence.
A 3-year gun specification, consecutive to a 3-year gun specification, consecutive to 4 to 6 years in prison. The defendant has credit for 55 days of jail time served. We're also asking that the court impose the mandatory post-release control that's required with a sentence on a felony of the 2nd degree of no more than 3 years, but no less than 18 months. Thank you.
You said there's 55 days?
Yes, Your Honor.
All right, I reviewed the pre-sentence report and the victim impact statement as well as the sentencing memorandum of both the state and the defense. And I have considered all the provisions in 29-29-11, 29-29-12, and 29-29-13. And as Mr. Bradley noted, I did sit through this trial. And boy, if there was anything more avoidable, I don't know what that would be. Now, Mr. Post noted that Mr. Quiggle took a picture or pictures of his vehicle, and that seemed to be the impetus for the entire episode. And then it was clear to me, as I sat through this trial, that from that point forward, that Mr. Post was intent on confronting Mr. Quiggle. There were, my recollection, 2 occasions, one at Sammy K's and one at, I believe, a gas station, where Mr. Post, you were trailing Mr. Quiggle, pulled into those places, pulled back onto 20, and then eventually caught up to him. Now, there was more than one way for you to get home that day, more than one route to take, and you didn't take it, because I think you wanted to confront Mr. Quiggle, and you did, to the point where he's turning left at it was McMacken. You get behind him, and he's looking out his window, probably shouting at you, and you get out, stand up, and you shout at him, follow him in. At some point during this entire episode, maybe still on Route 2, maybe just on 20, you took that firearm out of your center console and put it on the seat next to you. So I don't believe that you took that gun out because you were afraid that Mr. Quiggle was going to beat you. Okay, I think that you took that gun out and you fully intended to use that gun, which you did. And boy, how he avoided death is beyond me. So this was completely avoidable from beginning to end. And then there was...
A judge absolutely dismantled a self-defense claim during a shocking sentencing hearing after a road rage shooting left a man fighting for his life. The defense insisted their client was a respected citizen with health issues, no major criminal history, and decades of meaningful employment. They argued the shooting was an aberration, a terrible misunderstanding fueled by fear. But the judge wasn't convinced at all. He walked through the evidence piece by piece and exposed exactly why the jury rejected self-defense. According to the judge, the defendant repeatedly followed the victim instead of simply going home. He pulled into parking lots after him, got back on the road after him, and even took a completely unnecessary route just to continue the confrontation. Then came the chilling detail that changed everything. The judge said at some point during the chase, the defendant removed his firearm from the center console and placed it beside him, long before the shooting ever happened. That moment convinced the court this wasn't panic. It was preparation. The judge said he believed the defendant fully intended to use a weapon, and only luck prevented the victim from dying. Moments later, the courtroom heard the final punishment, multiple consecutive firearm specifications followed by years in prison. One reckless decision turned a roadside argument into a life-altering tragedy.
I believe some testimony that you left work sometime before, maybe 10 minutes before you normally do, and it takes you, I think you said, 35 or 40 minutes to get home. And this occurred well outside of that time frame. So I don't know what you were thinking, but it ended up where it ended up. So based on all the information on the firearms, you're proceeding on one, correct, Ms. Tuttle?
Yes, Your Honor.
All right. So I'm going to pose a 3-year firearm specification on count 1, the 3-year firearm specification on count 2, which are to be served consecutive to each other. And on the underlying offense on count 1, I'm going to impose a definite minimum term of 4 years up to an indefinite maximum term of 6 years. There's a presumption, and that sentence will be served after the gun specifications are served by statute. There's a presumption that on that 4 to 6 year that you should be released at the time the 4 years expires. And there's a possibility that could be extended up to 6 years, but you would necessarily have to be released after the 6 years. Whether you are released after there's a presumption you should be released after the 4. Whether you are depends on the criteria established by the Department of Corrections. If you are not released, you have the right to have a hearing to challenge that lack of the release. There is after you're released from prison, you will be placed on post-release control for at least 18 months up to 3 years. Conditions will be placed on you by the Adult Parole Authority. If you violate the conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which is a greater of 12 months, or the time left under post-release control. You have a right to appeal your conviction and sentence to the 11th District Court of Appeals. You have a right to have a lawyer appointed in that appeal because I'm going to presume you're going to be indigent now that you're serving this sentence. If you can't afford a lawyer, one will be appointed for you. You have a right to have a transcript of all the hearings that took place in this case. If you can't afford that transcript, it will be provided at public expense. And you have a right to have a timely notice of appeal filed on your behalf. Mr. Bradley, what is your desire with regard to the appeal?
Judge, we will be filing the notice of appeal. I do anticipate that we will be handling the appeal. But as you aptly pointed out, Mr. Post is indigent, and we would ask that the court provide a copy of the transcript at state expense.
All right, I will order that, but I would ask that you get an affidavit of indigency so we can send it down to the state public defender. But you will be appointed then on that.
Thank you, Judge.
Okay. Is there anything else, Ms. Tuttle?
Is the court granting the 55 days of jail time credit?
Yes, credit for 55 days.
Nothing further. Thank you.
Mr. Bradley, anything further?
No, Your Honor. Thank
All right,
you.
We're adjourned.
The tension inside the courtroom was unreal as a judge delivered a crushing sentence in a road rage shooting case that shocked everyone listening. Prosecutors described how Devin Quigley spent 11 days in the hospital after being shot multiple times, undergoing life-saving surgeries and suffering permanent damage that he'll carry forever. Yet despite the horrific injuries, the defendant continued insisting he acted in self-defense. His attorneys begged the judge to focus on his age, military service, health problems, and clean background. They argued he was not a violent criminal and asked for the minimum possible punishment. But the prosecution fired back hard. They said every critical choice that day belonged to the defendant: following the victim, carrying the gun, refusing to call police, refusing to leave, and finally pulling the trigger multiple times. Then the judge spoke, and the courtroom went dead quiet. He said the entire disaster could have been avoided if the defendant had simply driven home. Instead, he chose confrontation over and over again until someone nearly died. The judge made it clear he believed the firearm was prepared in advance and that the shooting was no accident. After hearing all arguments, the court sentenced the defendant to multiple consecutive prison terms, followed by years of post-release supervision. One road rage encounter ended with a lifetime of consequences for everyone involved.